He's fine. Before COVID. Hmm. Hmm. It's a nice score. The one in Detroit's nice too. I've been in that now probably more than I have here. Yeah, well, it's the same.
The same things.
Yeah. I don't think I've ever been in the Grand Rapids one. And I think the same. Well taken. You know. Hey, Adam.
Long time no see.
Yeah.
Hi, I'm David. It was actually, I think, in one of your booths. Oh, really? Yeah. Yeah, no, it's tough to, right?
Oh,
That was-
from
Oh, cool, cool. A little Sixth Circuit
Yeah,
action.
two going, both.
Yeah, you were, that's right. Yeah, I think I was on your mood for the one where you argued against the AG.
Oh, you're on my mood or her mood?
Your mood, I
Okay.
think, because I recognize your name and I recognize you from that, so.
Yeah, yeah.
I'm assuming, because I don't have any other involvement with the case.
When did you
That was-
start Adam at DG's?
I started in
We got a spare officer.
Only time there was a training and then,
Yeah, it's pretty sure.
Yeah.
the times to go down there. But no, we were on before.
Ah,
Morning. Hello, anybody there?
Morning, Ms. Roberts. This is the clerk's office, the Zoom host. The judge should be starting shortly.
Well, I need some information. We can't just get started. I don't know who the parties are.
Yep, I believe he will address that when he gets in there. Yep.
No,
when
I
he
need
sits
to
down.
know, the court reporter needs to know this information before. We can't just go on the record and just do it. I have to have the names before I get started so I can get set up on my end.
Okay, well, as the Zoom host, I apologize. I don't have that in front of me. I can get a hold of the clerk's office from the Court of Claims, but I don't know that we'll have that today within 5 minutes here, but I can certainly go try.
Can she hear us?
Yeah, I can hear. You mean to tell me you don't know who the attorneys are, who's gonna be talking?
Ma'am, we can give you that information if you can hear us.
Yes.
Okay, so
Hello?
I believe they have to go to the podium, Ms. Roberts, but for you to be heard. So if anyone in the courtroom is speaking to the court reporter, they'd have to use the microphone.
Is anybody gonna give me the information?
Yeah, please be patient. Ms. Roberts working on that right now. Okay.
Technology
Thank you.
Management Budget is the state budget office and the Department of, let's see. Oh, and that's it. Just the two, just two defendants. Do you think you have the necessary information, or is there anything else that you need?
No, you have not given me the attorney's name who are gonna be speaking. That's what I need.
So on behalf of the defense, I'm going to be speaking and my name is Adam R. DeBear and I'll let the plaintiffs respond to who's going to be speaking for.
But I don't know how to spell Adam's last name.
My last name is DE space capital BEAR, DeBear like the animal.
Okay, and who else?
And on behalf of the plaintiffs, it's David Porter.
Porter.
Correct.
And so how do I identify who's speaking? Because I have to see the faces so I know who's who.
I imagine and the judge has just arrived, Madam Court Reporter, and I'll at least identify myself when I speak, and I'm sure Mr. Porter will as well. But with respect to how the judge wants us to handle the hearing, I'll let him step in.
Okay. I think what we're going to do today is, since we only have one motion up, I'm gonna let the moving party go first, then the responding party go second, and then I'll give everybody a second round. This is a lot to talk about, and so I want to make sure that everybody has an adequate opportunity to be heard. It's my intention to write something rather than to decide this one from the bench. I've been knocking out a lot from the bench, but this one's a little too meaty for me to try to take out from the bench. So,
So Judge, who is the moving party that starts first? Which attorney is that?
that's going to be Mr. DeBear,
Okay,
and then Mr. Porter will respond, and then Mr. DeBear will go another time, and then Mr. Porter will close, and I'm sure I'll have a few remarks once we're finished.
okay, it's kind of hard when I'm not there and I can't see, so that's why I'm asking so many questions.
That's okay. That's no problem at all. Are you picking up their voices clearly now?
Yeah, I can hear. I'm just trying to get organized and, it's kind of hard when you're not there to see the people.
Right. Right. I'm just going to comment, and this is not for the record, that it's great that we have table mics now, because it used to be a wreck trying to do these sorts of hearings without table mics. So if the court reporter is picking up the table mic comments, that's great news for all of us. Okay. Is everybody ready to go? First of all, from the defense, are you all set?
Yes, we're all set, Your Honor.
And from the plaintiff side, all set to go?
Yes, Your Honor.
And from the court reporter's perspective, are you all set to go?
I guess.
Okay, let's go on the record then. This is case number 24-000097-MM. The City of Detroit Police and Fire Retiree Healthcare Trust and the City of Detroit General Retiree Healthcare Trust and the Retired Detroit Police and Firefighters Association against the Department of Labor and Economic Opportunity, the Department of Technology Management and Budget, State Budget Office, and the Department of Treasury, but it's my understanding that Treasury is now out of this case. Mr. DeBear, is that accurate?
That's my understanding, but perhaps it would be best if the plaintiffs could address that, because I believe there was a stipulation entered between Treasury and the plaintiffs.
Right, I saw that, and let me ask you, Mr. Porter, is it your understanding that the Treasury Department is now out?
Yes, they have been dismissed without prejudice.
All right, so we now have only the defendants other than the Department of Treasury. And that turns out to make a substantial difference because, at least as far as I can tell, counts 5, a FOIA claim, 6, a mandamus claim, and 7, another FOIA claim, are all against the Treasury. And so I think counts 5, 6, and 7 of the verified complaint are gone, correct, Mr. Porter?
That's correct.
Great. So we're down then to 4 claims. Count 1 is a due process claim against all three remaining defendants. Count 2 is an equal protection claim against only the Department of Labor and Economic Opportunity. Count 3 is a declaratory judgment claim against all three defendants who remain. And count 4 is a mandamus request against all three defendants who remain. Do I have that right, Mr. Porter?
That's correct.
Is that your understanding, Mr. DeBear?
Yes, that is, Your Honor.
Great. So that sets the table nicely for our discussion. I need to first tie up a couple of loose ends. There was an amicus brief filed by the Mackinac Center in this case. I read it last night along with all the other materials. Mr. Porter, I think you wanted an opportunity to respond to the amicus brief. Do you still want that opportunity?
We do, yes.
Very well. I will enter an order today granting you 14 days to file a response to the amicus brief. What I'll say about the amicus brief is that it makes interesting and important points, but it seems hard for me to imagine that I'm going to decide this case based upon an argument made only by an amicus. So I think it provides helpful context to the dispute we're having here today, but I don't think you have to worry about losing this case based on the argument made by the amicus. Is that fair?
That's fair. It was our understanding that that response had been filed. And we filed a motion.
Who's speaking?
Mr. Porter is now speaking.
Okay, so it's okay. Start over again, Mr. Porter.
It is our understanding that we filed a motion to be for permission to file a response and appended the response to that motion.
All right.
So it should be before the court.
Yep.
It is a very brief response, and because we recognize that the court is unlikely to go down that path if it doesn't need to.
Okay, Mr. Porter. Well, I can tell you this by way of an apology and an explanation. I not only have this case up on the Court of Claims today, I have a massive case up this afternoon. And when I left the office yesterday, I was handed a pile of papers that's about 4 feet tall. I did my best to go through everything that I had. I'm discovering that not everything was there. So for example, this afternoon, I was missing a response to one of the motions. And so I called and had it sent to me. I was not aware that you would file a response to the amicus brief, but it doesn't surprise me that you've done that. To the extent you've already sought leave to file a response, that request is granted. I will treat your response as filed, and I'll just go forward from there. But as I said, you really don't have to worry about losing this case on the basis of the argument made only by the Mackinac Center. If I start deciding cases based upon arguments made only in amicus briefs, I think I will lose control entirely of the process of litigating these cases the way they're supposed to be litigated, okay?
We understand. Thank you.
All right, now, I don't think that there's anything else that I need to take care of before we start the argument, but it has been my practice for years now to try to focus the argument by telling you what I think about the case first, and then letting you argue, because as I learned in my first few years as a judge 17 years ago when I started on the circuit court, if I don't focus the arguments, I'm likely to hear everything in the world that could be said, and I don't need to hear everything in the world that could be said. I'd much rather hear what's responsive to what's in front of me. Now, let me start by saying that I think it was Bismarck who said, "No man should see how laws or sausages are made." Boy, is this a good example of that. This is something that stinks to high heaven, but that doesn't necessarily mean that one side or the other wins. The way that I understand it, you have to go back in time more than a decade to figure out where this all began. Because when the city of Detroit filed for bankruptcy, there were a lot of affected entities and people who eventually got swept up in what is described perhaps hyperbolically as the grand bargain. And part of the grand bargain, which was designed, among other things, to save the Detroit Institute of Arts and its collection, was this deal where a lot of people had to take haircuts, for want of a better term. one of the groups that was going to get hit was all of the retirees from the city of Detroit who had expected pensions. It's one of the great tricks of legerdemain when you run a municipality, that the way you balance the budget in the present years is to promise people tons of money in the out years in exchange for concessions on salary. And sure enough, pensions are a classic example of that. And so there were all these obligations in future years to pay generous benefits to all of these people. And in the course of the grand bargain, all of those pensioners took a big hit. Now, if you want to try to understand what's at issue here, you need to know that the retirees who were the pensioners weren't completely shut out of the process. There was a system set up that would allow for payments in the future to be provided to these, for want of a better term, VEBAs. Now, a VEBA is a Voluntary Employees Beneficiary Association, and two of the three plaintiffs in this case are in fact VEBAs. There's the Detroit Police and Fire VEBA and the Detroit General VEBA. Everybody agrees that back when the city of Detroit came out of bankruptcy, and I think it was 2014, I could be wrong about the year, but in any event, there was contemplation that there would be these VEBAs, and these VEBAs would be able to obtain some measure of recompense for the lost pension benefits of the Detroit Police and Fire retirees and the Detroit General retirees. So that all happened in 2014. Fast forward 3 years after the city of Detroit had come out of bankruptcy, and we're going to have a whole discussion here about whether that bankruptcy is still open or not. Anybody who practices bankruptcy law would, I think, say that it's not still open, but in some parlance, I guess maybe it is still open. In any event, in 2017, there was a separate VEBA that was formed, the Coalition of Detroit Public Safety Unions Trust, which is referred to in the briefs as the Union or Unions VEBA. Now, after the formation of the Union VEBA, there were 3 VEBAs in play who were, I think, undoubtedly affected by the bankruptcy of the city of Detroit, the 2 plaintiffs and the Union VEBA. As the legislature is wont to do, they decided that there was all this extra money sitting around when they did the appropriations bill in 2023. And so they decided to throw $10 million at somebody. Now, the somebody wasn't entirely defined by the legislation. I mean, this isn't the cleanest kind of pork barrel legislation you could imagine where you just give money to a defined entity. It was kind of hidden behind this process for issuance of a grant in the amount of $10 million. And the eligible entities for receiving the grant were narrowly defined. It was essentially any VEBA that had been set up during the course of the Detroit bankruptcy. And what during the course of the Detroit bankruptcy means is a matter of some dispute. We'll talk about that in a moment. But in any event, there was a process by which people could apply for these grants. But there was a catch to the application. You had to have a legislator sponsor. And as a result of that, you or I or somebody like that couldn't possibly just go in and ask for the $10 million on behalf of an entity. There had to be essentially a post-legislative earmark placed on it. And what that meant is you had to get some legislator to sponsor your grant application. Now, as luck would have it, the Union VEBA happened to have somebody who was ready, willing, and able to be the sponsor for their grant application, somebody from the city of Detroit who was in the House. The other VIBAs, either for want of asking or for want of political power, didn't have a legislator who was a sponsor for their grant application. And the funny thing about it was they weren't specifically told that that was the problem. They were instead stiff-armed when they tried to file an application. Now, what happened underneath the surface is a classic story of power plays in Michigan. The Speaker of the House got involved and somebody asked some questions, and the next thing you know, the $10 million was given to the union VIBA, not to either one of the plaintiffs here. Now, whether that was an exercise in sheer political force or whether it was the intention of the drafters of that provision in the appropriations bill is a matter for discussion. But there's no question, I think, that Representative Carter was the sponsoring legislator for the one VIBA that received the $10 million. And no member of the House stepped forward as the sponsor for either the Detroit Police and Fire VIBA or the General Retiree VIBA. And so those two entities are now before the court, asking the court to award one or both of them $10 million. Now, I'm a little unclear about whether they seek $10 million in the aggregate or $10 million each. We'll have to talk about that as we move forward. But early on in the process, we've received a motion for summary disposition from the remaining defendants, the three governmental entities, all in the executive branch, excluding, of course, the Department of Treasury, which by stipulation is now out of the case. The request for summary disposition is based on Michigan Court Rule 2.116 C8 and C10. And I think we're all well aware of the distinction between C8 and C10. C8 allows for relief when the plaintiff has failed to state a claim upon which relief can be granted. And it's generally limited to pleadings. You can look at some attached documents, but that's about it. C10 tests the factual sufficiency of the claims, and it requires the court to look at all the documents that have been presented by the parties, although a C10 motion is generally premature if it's filed before discovery has been completed. And as far as I can tell, discovery really hasn't even gotten off the ground yet. So my typical reaction to a C10 motion at this point is premature, not interested in deciding it today. But I'm willing to listen because the facts really don't seem to be very much in dispute here. Now, if you go to the motion itself, you will see in the briefing that there are a couple of arguments being made for why this case should end now. The first one is a standing argument, and unfortunately, I went back and checked the dates the briefs were filed. This brief was filed back in August of 2024, and it lays out standing law largely based upon a published Court of Appeals case called T&V. Well, T&V died about a month ago. I happen to know that. I was watching it carefully because I was a dissenter in T&V, and the Supreme Court 5-2 emphatically and completely overturned T&V. And so to the extent it's relied upon by anybody, it's not good law anymore. And I think it's fair to say that its expansive reading of standing and mootness is no longer the law in Michigan either. So for better or for worse, I think the standing argument of the defendants is improved here by the fact that the new T&V takes a much more narrow view, primarily of mootness, but also of standing. Now, beyond that, there's an argument here, and Mr. Porter, you've put your finger on it. It's a little hard to tell whether it's a C8 or a C10 argument. It sounds like a C8 argument aimed at each and every one of the remaining counts, specifically counts 1, 2, 3, and 4. And I think, Mr. DeBerry, you're going to have to help me out with this. Your C10 argument only goes to standing, and your C8 argument goes to the viability of each one of the individual claims. I don't mean to say you need to respond and then leave you sitting there without a chance to respond, but we'll get there in just a second. And then, Mr. Porter, from your perspective, I'm a little unclear about the nature of your due process claim. I mean, obviously, due process can either be substantive or procedural. There's a world of difference between a substantive due process claim and a procedural due process claim. I think you're alleging procedural due process. If you are, then you have to show that you have some sort of property right that's protectable, at least insofar as a right to due process goes. I tend to think that's a stretch, and I'm not sure about it at all. With regard to equal protection, I think it's pretty clear that where we are on that is rational basis review, and that's the best you're going to get. I certainly don't think that this is either a heightened scrutiny or intermediate scrutiny case. And so if we're talking about rational basis, that's pretty tough to deal with. With regard to your claim for declaratory relief, I think you're invoking a constitutional separation of powers argument here. And the separation of powers argument intrigues me because this is a weird one where generally the legislature appropriates and then the executive branch executes by doing whatever the legislature told them to do. But boy, there seems to be an awful lot of legislative control retained by the way in which this provision is set up. In other words, a legislature has to be the gatekeeper for a viable application. So I'm more interested in count 3 than I am in count 1 or 2. And then the request for mandamus is going to be a tough one to win on because, of course, for mandamus, there has to be a clear duty and a clear right. Having judged lots of mandamus cases since I joined the Court of Appeals, this does not strike me as one on the promising end of clear right or clear duty. So that's where I think we ought to start the discussion. Mr. DeBeer, why don't you come on up to the lectern? You can go first. I hope you'll at least concede that what happened here makes you constitutionally queasy, because it sure makes me constitutionally queasy. That doesn't mean that you don't win. It just means that this seems problematic.
Right, and just for the sake of the court reporter, Adam DeBeer appearing on behalf of the state defendants, along with co-counsel at the table, Zachary Risk.
Is Mr. Risk going to speak today, by the way? Or are you going to cover everything?
No, Mr. Risk, though, however, is out of the two of us, the one with the most bankruptcy background, and he works for the division that represents the Department of Labor and Economic Opportunity.
Okay, I got it. The only other thing I'll observe before you get started, Mr. DeBeer, is your schedule is as jumbled as mine this week. I'll note that you were in Grand Rapids for a hearing yesterday and you did jump out of that to get in a Zoom call with me. So thank you for being present all over the state this week.
Thanks.
Go
It's
ahead.
a good time of the year to do that.
Oh,
And yourself,
sure.
and yourself as well, right? Having been in Grand Rapids. But no, I think that if anything, the process could have been sent out in a different, clearer and easier to manage way. But I do think that Your Honor is right that just because the process was the way it was doesn't mean that there's a viable claim presented here.
Right.
And with respect to standing, or sorry, the C8 and C10 aspects of our motion, Your Honor is correct, or is correct with respect to the merits-based arguments for, all of the constitutional claims as well as mandamus that are asserted. C8 from the pleadings and the attachments to the pleadings alone.
So in other words, once we stop talking about standing and we start talking about the individual counts, you're going to restrict yourself to C8 analysis.
Correct. That said, with respect to standing, we did attach, there's a question of whether the court can take judicial notice of these bankruptcy court opinions, but we did attach a lot of papers regarding the Detroit bankruptcy proceedings. So that's essentially the C8 to C10 aspect of our motion. With respect to, and I'll touch on separation of powers first, but then I also wanted to just identify what I think are the important allegations in the complaint and the important attachments to the complaint that I think this court should be considering when it decides whether they've stated a viable claim in their complaint. But with respect to the separation of powers, what you have here is you have the legislature appropriating money and then setting out a process which is to be followed with respect to how that money is going to be appropriated. And the legislature, importantly, didn't ask for legislative sponsorship or legislative approval. They asked for a sponsorship or a sponsor by one legislator. And
Okay, but just to be clear about that, you had to get a legislator who essentially would step up and support you, right? With your argument on standing is without the benefit of a legislator being the one carrying the water for you, you didn't even get in the door to have the conversation with the executive branch.
correct. And there's a time frame here, right? Which I'm sure you're aware of the pleadings or the motion papers. But before January 15th,
Right.
2024, if there was an entity with a legislative sponsor, that was the entity which was going to get the grant appropriated. If there was no legislative sponsor after January 15th, then the department could either identify itself as the sponsor or decline to award the grant. And that level of discretion,
What would have happened to the $10 million if they had declined to award a grant?
it would have reverted back to the general fund, having lapsed at the end of the fiscal year. So
Okay,
it would have went
That's what I
right back.
thought, but I just wanted to hear you say it. Got it.
Right, because there was never any legislative appropriation for the Department of Labor and Economic Opportunity to use it for any other purpose. It was only, it was only for that purpose. So it would have reverted. And that level of discretion, just as an aside, defeats any claim of property interest, is the state defendant's position.
I think you're right. I can't see how they can possibly get past C8 on count one. I just, unless it's a substantive due process argument and I'm misreading the pleadings, I don't see any property right. or-
There is substantive due process and procedural due process, or there are both counts in the complaint. But even substantive, a substantive due process claim also requires a property interest at stake, and there's no property interest for either claim is the state defendant's position.
Right. Well, I mean, substantive due process can be a lot murkier. It's basically air rights. I mean, it has no defining concept.
Right, and it's the source of several Sixth Circuit opinions of scorn saying, well, you can't just shoehorn a claim into substantive due process. You should try to go for the particular constitutional amendment that's more.
Exactly. I mean, a third of Robert Bork's book was about how substantive due process is wholly illegitimate because it has no defining parameters
Right,
or principles.
difficult for the bench and the bar alike.
Right.
But with respect to the separation of powers, I think, and I don't have the case citations off the top of my hand, but they're in our brief. Generally, even if this is a legislative intrusion into the executive sphere, the executive is free to acquiesce, to not challenge the legislature, and it also has the duty to follow the law until a court has declared that law unconstitutional.
Well, let me ask you this. Let's say that it required that the sponsor be the Speaker of the House. Nobody else. One person controls where $10 million goes, in effect, right?
I think it's a little murkier in that instance. I think what the lack of that specific requirement is it allows the particular representatives of the various districts where their constituents reside to decide which particular entity would be best situated to receive these funds and administer them and disperse them in a manner that befits a public purpose.
Right. Well, picking up on a thread from the Mackinac Center brief, I mean, you certainly have to concede the way that this appropriation was structured, it had to be somebody in the city of Detroit who got the money or some entity, right?
Correct.
I mean, it's a city with more than 600,000.
It's the only city with, I believe, the only city
So,
with more than
right,
600,000.
so they defined it down to one city, so it's
Right.
got to go to somebody in the city of Detroit, right?
Right.
But I suspect one of your positions is that the legislator sponsor shouldn't have been an insuperable barrier to an application by either one of the plaintiffs because they could have gone to anybody. I mean, it didn't even
Right.
have to be somebody from the city of Detroit. They could have found somebody from the Upper Peninsula to be their sponsor.
Right. Presumably, it would have been someone from the city of
Right, right.
Detroit,
I
but
mean,
it didn't,
right.
right? It
Yeah,
could have been a
right.
representative, it could have been a senator,
Right.
it could have been, from anywhere throughout the state.
But right, there's not a requirement that it be somebody who represents the city of
Right.
Detroit. I mean, they could have gone anywhere to try to find somebody to
Right.
be their sponsor.
And there's no prohibition against members of the public, whether they be individuals or entities such as the plaintiff Vibas here, to reach out and to contact their legislators
Sure.
that represent them.
Sure,
So
sure.
everyone in theory was free to reach out to a legislator and seek legislative sponsorship.
So in your view, then, this isn't something that is set up as an impediment that becomes an absolute insuperable barrier. It's just one more box you have to check. Get somebody in the legislature,
Right.
House or Senate,
Right.
to essentially carry the water for you.
And importantly, the legislature structure here enabled the state budget office and the Department of Labor to administer this, $10 million that was awarded to the Department of Labor and Opportunity Labor and Economic Opportunity, or LEO, without having to, distinguish between various potential applicants or anything like that. There's a legislative sponsor, and it's the grant will be expended in a manner that's for a public purpose, and you have that legislator attesting to all of that. Well, it's an easy to administer grant program.
Okay, so just to be clear, before we get into the messy facts here, if each one of the plaintiffs had gone out and obtained a legislative sponsor, somebody went to West Michigan and somebody went to the Thumb area, and so each one of them had a sponsor, not somebody from the city of
Right.
Detroit, but just a sponsor, then the discretion would have been left entirely to the defendants in this case to decide which of the three applicants received the $10 million.
Right, and I believe, and I'd have to go back, I have the excerpt from the Public Act here with me, but I'd have to give it a closer review. But I believe if, for example, before January 15th, the three potentially eligible VIBAs, at issue here,
Right.
if each of them had a separate legislative sponsor, then I don't believe the state budget office or the department or LEO would have been able to ascertain the particular entity that was to receive the award, because there would be three potentially eligible applicants in that period of time, in which case they would have had to go through more procedures to figure out which one to award them to.
Right.
Still within the discretion, but
Okay, now, timing matters here. So after January 15th, there appears to be some confusion about who the money was supposed to go to. And so they reach out to somebody
Right.
on behalf of the Senate and somebody on behalf of the House, and they say, okay, who's supposed to get this money?
right.
Which is a weird question to ask if it really is a grant with an application. But in any event, they get the word back that both the sponsoring House member and the Speaker of the House want the money to go to the union's
Right, and it was.
Viva, right?
Right, and it was Representative Carter who originally authored the sponsorship form and identified himself as the sponsor of that
Right, right.
application. But
right.
yes, you're
Yeah, I'm
correct.
not saying that they weren't transparent about it, but I mean, but did that happened after January 15th, right?
So I believe the initial questions presented by the plaintiff Vibas to Leo were before January 15th.
I
But yes,
understand they were making inquiries, but
the communications that you're talking about, where there was a sudden bit of uncertainty with, is this who, that did occur after January 15th.
yeah, right. I mean, there's no doubt they were knocking on the door before January 15th. I mean, you have to concede that,
Right.
right? I mean, there were
It's
meetings taking place.
we have the public records attached to
Right.
the complaint.
Right, right. I mean, there's no question that they were trying before January 15th to apply, correct?
Correct.
All right, but they never got a sponsor, and you view that as fatal. But I think the point is, to the extent that there were these arguably improper conversations about, hey, forget what the appropriations legislation said, who's really supposed to get this money? That took place after January 15th. And at that point, the application process had closed.
Correct.
And so there was only one applicant. And so even though that sounds really kind of dirty, the way that conversation took place, at that point, that was the only answer that could be given. It's supposed to go to the one applicant you have.
Right. Otherwise, if there are no eligible applicants before that
Right,
time
right.
period, then it's completely within Leo's discretion whether to award the grant or not. And those communications, I believe, took place because of the questions that plaintiffs were asking and that they were submitting that they were eligible.
Oh, right.
And then you
Right, I mean,
had
Susan
the,
Corbin clearly was concerned about the pickle that they
We
were.
have
Right.
a lot of
You had-
overlap. Can we have one person speak at a time? Because I can't hear it when two people are speaking, so the record is not going to be correct.
I apologize. I'll do my best going forward. But
Last
yes,
thing I got was we're asking, the last few words were asking, and they were submitting that they were eligible, and then someone else said something, and you said something. I don't know what that was.
I was the someone else who said something, I believe.
It's okay. Don't worry about that. That was just crosstalk. I'll let Mr. DeBear have some free air now.
But yes, essentially, Your Honor, that communication that happened after January 15th was when there were questions presented related to the bankruptcy, related to whether this entity was eligible, and the executive branch wanted to ascertain whether they were awarding it to the appropriate entity. And once they determined that by reaching out to the legislative sponsor, because Carter was both the sponsor before that time and he was a member who was reached out to after that time, we have that confirmation. Yes, we can be assured that we're complying with the terms of the statute and giving this money to the appropriate entities. And I think from a separation of powers standpoint, general appropriations, and there's not a lot of case law on it. There's some attorney general opinions from Attorney General Kelly and even some attorney generals before Attorney General Kelly. But essentially, as the court summarized at the outset, the legislature appropriates and the legislature expends. But when the legislature appropriates, it's free to attach conditions, frameworks, et cetera, to those expenditures. And all that the executive branch did here was comply with those additional requirements that the legislature enacted.
Right. No, I understand that. But what makes me nervous about it is if this is something that I have to approve, it could just as easily be the case going forward that the Speaker of the House could put in place an appropriation for $10 million with a grant application process, but only the Speaker of the House could be the sponsor, and then the Speaker of the House decides to sponsor his son.
I think if there is a process such where the legislature actually needs to, the legislature actually needs to approve the expenditure after it's already appropriated to the department, that clearly violates separation of powers. But in this case, it was different. In this case, it was narrow, and it was one legislator who not only had to sponsor the particular grant, but had to explain whether that grant was for a public purpose, whether or exactly to what extent those funds would be used and how they would be benefiting the community. And I mentioned earlier that the portions of the complaint, I wanted to run through with the court. I actually have it here, I believe.
Well, before you do that, let me just make sure that I understand what we're talking about, because your threshold argument is one of standing. And although standing is a prudential doctrine, if they lack standing, the case just ends as a matter of what in the federal system they describe want of case or controversy.
Right.
And so as far as standing goes, the reason I want to focus like a laser on January 15th is I think for purposes of your standing argument, everything that happens after January 15th is effectively irrelevant.
Right, because at that point in time, there was only one entity who satisfied the eligibility requirements for this particular grant. The plaintiff VIBAs are not situated differently from any other member of the public or any other potentially eligible VIBA in the city of Detroit, namely because they didn't satisfy those threshold criteria.
Well, let me ask you this, because this is something that's bothering me. Let's assume that the Detroit bankruptcy ended for purposes of analysis when the city came out of bankruptcy in 2014. I think you concede that the union VIBA wasn't set up until 2017, right?
It wasn't set up prior to the confirmation of the plan by the district court in 2014 or whatever, or by the bankruptcy court in 2014. It was after that. It was after that point in time.
All right, so unless I accept this argument that I'm not so confident about, that the Detroit bankruptcy remains open even to this day, let's assume that the union VIBA wasn't eligible to receive this money because it wasn't created while the Detroit bankruptcy was open. What would be the consequence of that for this litigation? Because I don't know that that makes their claim any better. It might mean that the union VIBA got $10 million it wasn't supposed to get, but I don't see how that helps them.
Right, and it doesn't, because they weren't ever eligible to receive the grant application because they never met all the requirements to receive those funds. And even if there was a question about, whether it shouldn't have been awarded, you go past January 15th and it's completely within the department's discretion to even award the grant funds, meaning they were never entitled as a matter of property, essentially, to receive or to apply for those grant funds.
So if there were any consequences flowing from the fact that the union VIBA didn't exist early enough to be eligible to receive the funds, that would, I suppose, just lead to a controversy between the executive branch, if it wanted to try to recover the funds, and the union VIBA trying to assert a right to hang on to them. But I don't see how that helps them at all.
No, and I don't think anywhere in the motion papers have the plaintiffs attempted to demonstrate any sort of, taxpayer standing or any other special sort of standing that would enable them to sort of attack that potential expenditure of state funds, because again, they are situated exactly the same as any other individual or entity within the state of Michigan, in that they were never qualified to receive those funds or entitled to those funds in the first place.
And I suppose the reason that you need to go outside the pleadings is simply to establish that only one applicant met the qualifications.
Correct. And again, and I know Your Honor has expressed disagreement or at least some skepticism with respect to the argument, but clearly the legislature did not use technical terminology in its boilerplate. They used general terminology, and that's where our argument flows from, is the plain language, not in any sort of technical meaning, because as of June of 2024, several months before briefing in this case, the city was saying, bankruptcy court, please keep this case open because we still haven't finished paying all the debts that we need to under this schedule. The proceeding itself is still open, and I think it's beyond the realm of argument that the union's VIBA formed in 2017 wasn't formed during the bankruptcy proceeding.
Well, just to be clear about this, though, the city of Detroit emerged from bankruptcy in 2014. Now, they had obligations under the plan, but the plan was approved in 2014.
The plan was approved in 2014. Whether or to the extent that that needs to be described in layman's terms, I think that's another issue. But if we're looking at this in lay people terms, the legislature couldn't have been clear with saying during. It didn't use technical terminology. It said during, and during is a pretty easy to understand meaning. And that bankruptcy proceeding, I don't know, I didn't check before the hearing, but I believe it's still open. The last status report was in December of 2024. So I believe the proceeding is still open.
But as I understand it, the plan actually referred to these two plaintiffs. And of course, it couldn't have referred to the union VIBA because it didn't exist yet.
Correct. But as we've attached in the extra papers, there was motion practice regarding other VIBAs whose retirement benefits were going to be negatively affected, and that's where this union's VIBA came from. And we've attached those papers. But as Your Honor picked up earlier, even if you're skeptical of this argument, even if we're wrong that it wasn't formed during the bankruptcy, plaintiffs have never, as a matter of law or fact, satisfied the threshold requirements to receiving this entity. Therefore, they can have no standing. And along with standing, even if we get into the merits, there's no property interest for those same reasons. And separation of powers, this is a mere plan put in place by the legislature. And if there's any question of overreach, the executive branch is perfectly able to acquiesce if it, you know, decides to. And another thing, the executive branch can't just not, you know, we're not going to listen to the statute because it's unconstitutional. There's case law out there that says we have to wait for the court to decide constitutionality before we act. And just briefly, I believe it starts at paragraph 60. I won't go through paragraph by paragraph. Plaintiffs acknowledge all of these requirements. They acknowledge all of the statutory requirements. And then it's exhibit 5 and 6 in their complaint, which they attach the process that the State Budget Office and Leo came up with to administer these plans. They attach the legislative sponsor requirement, and there's no need to, if this court gets out of standing, there's no need to go outside of plaintiff's complaint to resolve the issue.
I see, but generally, the court can consider attached documents only if there's something like a contract. Now, I get it. They voluntarily put these documents into the record as attachments to their complaint. And I don't have 2.113 in front of me now, but my recollection about what MCR 2.113 is, it says something to the effect of you have to attach a contract if the action's based on a document.
Right, and I think that's it's going back. We don't typically handle a ton of contract litigation. We have procurement, but not a lot of active contract litigation. So I'm going back to my days as a law clerk. But I believe that's specific to contract actions. And if you don't attach the contract to a copy of your complaint, I think it's subject to dismissal, of course, with, you know, free leave to amend to attach the copy of the contract.
Yeah, give me just a second to take a look at this and see what it says. It is MCR 2.113C. I have the 2022 version of the rules, but I'm sure that it's similar to what it is today. It says if a claim or defense is based on a written instrument, a copy of the instrument or its pertinent parts must be attached to the pleading and labeled according to standards established by SCAO, unless the instrument is, and so on. And then under MCR 2.113C2, it says an attachment or reference to an attachment under subrule C1A or B is a part of the pleading for all purposes.
Right.
So your view is that if I read that broadly enough, I can actually look at all these documents attached to their complaint and treat it as a C8 motion.
Correct. And I think that, you know, there's several cases that say essentially the same thing with respect to C8 motions. But if there's no viable path for recovery at the outset, the court can grant the motion under C8. And I think just because I messed up that quote just a little bit, I believe it's the case that I have is Kuhn versus Secretary of State 228 Mishap 319. It just talks about if there is a claim that is clearly unenforceable and no factual development could justify a right of recovery, dismissal under C8 is appropriate. And I submit that that's the case here, Your Honor.
Oh, sure. El Khalil from the Michigan Supreme Court,
Right.
Unanimous. I can't ever remember. I think it's in 496, but whatever it is, it's El Khalil.
Right.
And it draws a really sharp distinction between C8 and C10 analysis. And your view is, although you suggested C10 is the basis to rule on standing, you don't even have to get there. You can get there under C8, just looking at what's attached to the complaint.
Right, and doing so wouldn't take into account whether the union's VEBA was eligible to receive the grant monies or not. It just focuses specifically on the ineligibility of plaintiffs' positions.
Thank you, Mr. DeBear. That's all very helpful. You all set?
Yes, thank you, Your Honor.
Mr. Porter, come on up to the lectern and I'll give you some free air to fly, but I suspect you know what I'm going to ask you.
Well, yeah, I'm happy to start wherever you'd like, answer any questions you may have.
Let's talk about standing first then, because I worry, even though there are lots of things about this case that make me really uncomfortable, about whether you ultimately can prevail at all, because neither one of your VEBA clients filed an application by January 15th.
Yeah, I think the question is, if not us, then who? We are the only two VEBAs in the world that meet the written qualifications in 1010 sub 8. No one else in the world, not even this third VEBA, we would argue, but let's make it 3. We were the only three entities in the world that have a special interest in seeing the department follow the statutory process and a constitutional one to make sure that those funds are distributed correctly.
Well, tell me what's wrong with the requirement that you have to have a sponsor who's a member of the legislature?
It violates the separation of powers and it violates equal protection of the laws. I'll quote from their brief explaining the purpose of the legislative sponsorship requirement. It confirms how the section 1010(8) funds will be used. That's a quote. Quote, serves as a mechanism to confirm compliance with the legislature's intent expressed in section 1010(8). Well, that's just another way of saying they're interpreting the law in order to enforce it. And under the Supreme Court case that we've cited, that is a textbook definition of a violation of separation of powers.
But just to be clear about this, in order to get a sponsor, you had 148 opportunities, right?
We challenge that. What you've heard today was a factual recitation that we don't know is true or not. The entire discussion that has gone on this morning assumes that we could have gotten legislative sponsors. We suspect in discovery we will find that there was only one legislative sponsor, that this entire system was set up so that one representative would have responsibility over one provision. Now, of course, that would be an egregious violation of separation of powers of Article 4, Section 30, which is, of course, why they can't come out and say it here. But we think that that's what the discovery will show. And of course, if that's what it shows, then of course we were excluded from the process, which is why we weren't given a response to our inquiries early on in the process.
Right.
All of those are factual issues that we are entitled to explore in discovery.
Right. And that's what I'm most worried about here. I don't know it, but I'm suspicious that this was all just kind of a charade.
And to quote what Mr. DeBear said, if there is no circumstances under which factual development can prove a claim, then sure, you can grant the motion. But it sounds like there are circumstances in which the facts would bear out our theory. And if that's the case, you cannot grant the motion under C8. It's just that simple. Now, with the question of standing, I think it overlaps with the property interest question. And we would push back a little bit and say, being the only two, maybe three entities in the entire world that is entitled to these funds, we have a legitimate claim of entitlement to these funds.
Well, stop for just a second, because I need to explore that a bit. Are you arguing that each one of your clients has a viable claim for $10 million?
So let me be very clear about what our theory is in this case. We are not saying that we are automatically entitled to these funds. What we were entitled to is to participate in the statutory process. If they were not able to determine from the face of the statute or public supporting documents that this could only go to one recipient, then they had to follow the procurement statutes. They knew as early as September of 23 that this could go to two, maybe three VIBAs. Under those circumstances, they had to follow the procurement process. How that would have played out, we don't know. We'll never know because they excluded us from that process. That is what we are constitutionally entitled to.
Okay,
the same as the.
But what does that mean then? That if you win, we start the process over again?
So, well, then it just gets to a question of relief. And they haven't raised this issue, and so I don't know that we need to address it here. But that is a question of what kind of relief can the court order at this point? We've asked for a declaration that this is unconstitutional, both on its face and as applied in our situation. You can also order injunctive relief. But if the money has already been spent, then under Mays and Bowserman, if there is no other alternative remedy available, money damages.
I see. So Bowserman gives you, in effect, a direct action under the Michigan Constitution.
Absolutely. Which goes to the point about standing, which I don't want to overlook here because we've talked about it in the context of us being an interested party. Under Lansing schools, the question is very simple. Do we have a cause of action at law? If we do, then quote, standing is not an issue. We have a cause of action at law. It's procedural due process, substantive due process, and equal protection. All three are constitutional torts. Under Bowserman and Mays, we have standing to bring those claims.
In your view is, I can't get to any of those and get rid of them under C8. So for example, equal protection, I think you'll concede, gets you only rational basis review, right?
Correct. And it is irrational and arbitrary to use an unconstitutional means to serve what we would agree is a legitimate government interest.
Talk to me about count 3, because typically, if you want to bring an action for declaratory relief, you have to have some underlying claim. Is your underlying claim based on a specific provision of the Michigan Constitution of 1963, or is it simply based on the broader concept of separation of powers?
Both. What has happened here is that they've excluded us from the process. under the guise that we didn't have some legislative sponsor. The problem with that is that requirement is a clear violation of the separation of powers. And so you can't untangle those two theories. So yes, we were excluded from the process. That's a substantive and procedural due process violation. But they used a means to distinguish between two grant applicants using irrational and arbitrary means. That's a violation of equal protection. And the means that they used is a textbook violation of separation of powers. It is much worse than the classic examples that we have from the US Supreme Court, where you had somebody who was removable at will by the legislature involved in the execution of the law. We have a sitting legislature deciding how to interpret the law through back channels, saying, no, it should go here. And it's even worse than that because it wasn't just the legislative sponsor who was directing where this money goes. It was Speaker Tate. You've asked the hypothetical. That is this case. Speaker Tate got involved and said, no, the money goes here. So they've actually gone outside the statutory process. All of it, I think we have proven enough on our facts and our allegations to get into discovery to prove whether or not they follow the statutory process as they claim that they have.
Well, I think they followed the statutory process because after January 15th, they had only one applicant, but there's no question that at every stage you were given the stiff arm. I mean, I don't doubt that your clients were trying to the very best of their ability to file a grant application, right?
They did not follow the statutory process because they could not determine from the face of the statute or from public supporting documents that there was only one recipient for these funds. They could not have done that before or after January 15th. So that is a violation of the statutory process. And they knew that they were not following it. They had all this information at hand, and they were communicating back channels, knowing, I think it was Director Corbin who admitted to her staff, this is going to be a problem. We need to make sure that we do this properly. So we have all the facts here, the entire recipe for a constitutional tort, and certainly should be able to get into discovery to pursue this.
And I suppose the reason you can pursue a Bowserman type theory is because there's no other available remedy, right?
Yes, and we're happy to brief that, and we haven't reached that stage of the case yet to decide, is an injunction available? Could it give us the relief that we need? We don't know that. We don't know where the money is. We haven't been able to determine, if all of it's been spent, if the Union Viva still has it. We don't know. So unless there are any other questions that you may have, I think that we certainly have pleaded enough to show that we have a property interest in these funds.
Let me ask you this, because you did attach a lot of valuable documents to your complaint. May I use those in resolving the motion in front of me?
The answer is, well, no, if it's going to be a granting of the motion. Because here's why I would say that, because it would require you to interpret some of the documents. The reason why we attached it is to show that we have enough to get into discovery. We have enough. This dog is going to hunt. They've pointed to the special grant process document that's been provided to all the legislative offices, as though this is the process that they followed, as though every legislative office would have been entitled to submit a sponsor form. We think there are two ways that you can read that document. And we think that'll bear out our theory and not theirs. So I know it's a cute answer to say, no, you can't if it's going to be an adverse decision, but we think there's enough there in those documents to at least get us into discovery.
Thank you, Mr. Porter.
Thank you.
Very helpful. Mr. DeBear, I'm not going to ask you many questions now. I'm going to let you clean up whatever you want to. The only thing I'll ask you is not go on for half an hour because I think I have this. I don't know what the answer is yet, but I think I understand the problem.
Right. I think the first thing that I want to address too is the concept of standing. Just because there is a cause of action, meaning there's a right under Bowserman to sue under the Constitution, that doesn't imply standing. Standing, a party has to actually have an injury. They have to have an injury of which, Bowserman essentially was unemployment benefits where property interests were involved, unlike here. But Bowserman is where there's a right, there's a remedy. Where there's an injury, there's a mechanism of seeking redress. There's no injury here. So the distinction between Bowserman, constitutional tort, therefore there's a cause of action under the Lansing Schools analysis is not the question. The question is whether a cause of action exists, and none does exist because there was never a point in time in which the plaintiff VIBAs were constitutionally, or not constitutionally, statutorily eligible to receive those funds.
Right. I think at bottom, the fundamental disagreement between you two is that they presuppose that they have some right they can assert to this $10 million. You, on the other hand, don't think they have any right they can assert to the $10 million. So no matter how this case comes out, the award to them can't be $10 million.
Right. There was only one $10 million appropriation for one entity, and that one entity had the sponsor. And I think it's clear that that they never had a right because they never had a sponsorship. We heard from Mr. Porter essentially that the plaintiffs were excluded. And I know the court mentioned that there was some stiff arming involved, but they were never excluded by defendants from participating in this process. They had the ability, as we discussed earlier, to reach out to their own legislator, whether it be House of Representatives or the Senate, to get a sponsor and to get them through that January, or get them, through the door in advance of the January 15th deadline. They didn't do that, and that's the sort of the end of the story. And the conversation, excuse me, the conversation with Leo about this being, potentially a problem. Well, we were sued. The Department of Labor was sued. The director predicted a lawsuit, and they were talking about the lawsuit, but it wasn't trying to figure out how to exclude anyone from the process. It was, okay, we have two entities saying that they're entitled. We already have the legislative sponsor from Tate, which was before any of this potential stiff arming or backhandedness. Tate's sponsorship came first, and and Leo just simply wanted to make sure that it had the information, it understood the information presented to it correctly. And guess what? It did. The union's VIBA was sponsored by Tate. Therefore,
Not Tate. It's
sorry,
Carter.
Carter. Yeah,
Representative
Tate was the
Carter.
speaker, right? And then the only other thing that I think is somewhat difficult for the plaintiffs to even have, even if this court were to put it through to discovery, essentially what plaintiffs are saying, looking at the Mackinac Center's brief, is they're saying, well, these grant applications were not unconstitutional because the legislature can define it in this way. But this requirement here for the legislative sponsorship was unconstitutional. The grants themselves are okay. The process wasn't, so that the executive should have disregarded or been prohibited from complying with these supposedly It's just a long way to go to where it ends up with property rights were damaged, because as we've established at the beginning, there was never a point in time in which they had any eligibility. And unless Your Honor has any additional questions, if you have any questions with respect. Oh, one thing I did want to note too, with respect, because we didn't file an amicus or a response to the amicus brief. I'll note for the court, and I won't read the citations, but the case, and I believe it's in our reply brief in a footnote, Grebner versus State, a Michigan Supreme Court opinion, and from 2007, essentially stands for the proposition that the legislature determines what constitutes a public policy, and what constitutes a public purpose.
Right.
Essentially, to determine that, it involves consideration of political science and government and social, and that's supposed to be done by the representatives of the people as opposed to the courts. And the legislature stated in the act that these grants were for public purposes. Speaker Tate, after the fact, through the process, ensured the executive that, yes, this is what it's for, and it's for a public purpose. And that initial grant from the Public Act, that determination should be final, because as the court, can see if it looks at the city of Mount Pleasant versus the state tax commission case, public purpose includes things as broad as economic development, things that are generally, for the betterment of the society. And how couldn't a plan to aid retirees who had their benefits from the largest city in the state in public safety, how could that not be for the betterment of the morals and society and health of the general public? It doesn't change it into a specific or local grant. And I would submit it still falls within the definition of public purpose set forth in Wayne versus County of Hathcock, the famous takings case, as well as city of Mount Pleasant versus the state tax commission.
Well, just to be clear then, Mr. DeBear, I don't want to go down a rabbit hole if you're not inviting me to go there because you're the moving party here. What I'm hearing you say is you do not subscribe to the position in the Mackinac Center
Correct.
brief. All right, and so you do not want me to resolve this case on grounds identified by them, even if it might result in you winning the case.
We don't need to get there to win this case at all, because for the reasons that we've said that I've mentioned previously, there is no injury and there was never any eligibility to receive these funds. So even if there was a constitutional violation, which the state says there wasn't, doesn't matter for plaintiff's case. It still has to be dismissed.
Thank you.
Thanks.
Mr. Porter, I think that cleans up any concern you may have about the amicus brief. I'm not going to prevent you from filing your response to it, but Mr. DeBear has disclaimed any reliance on the theory there.
Your Honor, the funny thing is that if you accept their argument, you will be walking into that very problem, maybe in this case, because if so, if you adopt their reading of the statute, which I'll get into in just a moment, this is where this all stems from. If you adopt that reading of the statute, then we would request leave to amend so that we can bring this very claim. So, but if it's not in this case and they prevail on this argument and you decide the case in that favor, then the state will be precluded under principles of collateral estoppel from taking any other position that there was only one entity in the whole world that could have been awarded these funds. And if so, that is a textbook violation of Article 4, Section 30. It is a private appropriation, notwithstanding any public purpose. It was not passed by a 2/3 vote. So this provision and the hundreds of others in the Appropriations Act, last year, this year, the next year, all of those will go down if you accept their reading of the statute. The reason why I say their reading of the statute is because they're claiming we're not injured. We can't come to court and bring these grievances because having gone through the process, we've determined that there's only one eligible recipient. But that conflates eligibility with actually being awarded the funds. And we think that's a significant misreading of the statute. It's almost circular. It's like you're using the results of a process that you've excluded us from to say, well, you can't complain about being excluded from the process. It's Orwellian logic is what that is. So, and the same thing goes with the due process. I think they go hand in hand. You cannot say that we don't have a property interest just by simply pointing to the fact that it was given to somebody else. We are in a better shape than the liquor license holder in the Bundo case, the school district in the Galion Township case. There was no guarantee either one of those would have gotten the grant recipient. And I should point out that the department actually has no discretion not to award these funds. The statute says these funds, quote, must be awarded. So this notion of there's some discretion that we wouldn't get the funds, I think is a stunning admission from a department who's up here touting that they're just following the statutory process.
Well, stop right there because in their argument, the precondition is you need a legislator to be your advocate or your sponsor, whatever term you want to use. So in your view, what would happen if nobody had come forward with a legislative sponsor?
The problem is, in our view, that requirement shouldn't exist. It shouldn't be in the statute because it's unconstitutional. So that's the circularity problem with their argument, is they're assuming the conclusion of our merits argument in order to back end us on standing. You cannot assume the merits. You can't decide the merits of our case. So in a world where the legislative sponsor requirement doesn't exist, you have two plaintiffs who have come in and shown that they are at least facially eligible for these funds. You have no discretion not to award these funds. They must be awarded to one of the two VBAs that are eligible. Now, the question of whether there's a third and maybe we gave it to the correct one, you're right. We don't need to prove that they should or should not have gotten the funds. We're not here claiming that they were not, quote, eligible. But there is at least a question of fact, because if their argument is based on the fact that there was only one VBA eligible, there's definitely a question of fact of whether or not they were eligible. We think it's a very strained and motivated reading of the statute to say that VBA that was formed in 2017, 2 years after Detroit exited bankruptcy, was, quote, formed during the bankruptcy. But let me add a little bit more flavor to that, because in order to meet the eligibility requirements, their members had to have had their benefits reduced as a result of the bankruptcy. The only people whose benefits were reduced as a result of the bankruptcy were our clients, current retirees at the time. The third union VBA, they were current employees at the time. They had no benefits reduced as a result of the bankruptcy. What happened was
they may have had prospective future benefits reduced in effect, but it's not the sort of direct harm that your client.
And so now we are suddenly in a realm where we are reading the statute in such a strained way that it defies logic that that would be the person that they're intended for. So there are a lot of questions of fact, and one of which is, were their members' benefits reduced because of the bankruptcy? We'd like to get into that.
Right. And I certainly will concede that it's in your favor that your two clients were mentioned in the plan. And obviously the union VEBA couldn't possibly have been mentioned in the plan because it didn't even exist.
Absolutely. That's correct. And so given all this, we don't need to prove here today that they were or were not eligible. All we have proven, we've alleged enough to show that there were only 3 entities in the world. We certainly have a legitimate claim of entitlement to at least apply and participate to those funds, just like the liquor license holder in Bundo, just like the school district in the Galion Township case. And so, and for the same reasons, we also have standing. That's my answer to the amicus brief. There are 2 ways to read this statute. You should read it in our favor and avoid all the constitutional problems that the amicus has pointed out, because if not, either we or somebody else will be here using their words against them. All right, thank you.
Thank you, Mr. Porter. I'll just close with this observation. I've been a lawyer for almost 40 years and a judge for almost 17. And when I was a lawyer, I worked at the Office of Legal Counsel in the Department of Justice, which dealt with the trickiest constitutional issues. This is one of the best constitutional disputes I've ever seen. I don't know what I'm going to do. I'm going to talk to my commissioner who's been sitting in the back listening. We're going to try to figure out where to go, but I'm going to try to write an opinion that makes it very clear what the path forward is. So be a little patient with me on this one. I would like to turn my undivided attention to it beginning tomorrow because it's the most interesting case I'll see all year. But unfortunately, duty calls and I'm sitting in February and I have to get those opinions done as well. So I promise as quickly as I can. Okay. And thank you both very much. Excellent arguments this morning. Fascinating issue, and I'll try to do it justice. Thanks, everyone. And we can go off the record. Thank you very much to the court reporter, and we will close this proceeding. Thank you.
Thank you.
We want to order the transcript. The transcript.
Yes, if the question is, do I want a transcript? The answer is yes, please. Okay, we're not recording or live streaming anymore, are we? Just a moment.
Yep, we're still live. I'm taking that down right now. 1 second.